All rise. This court is now in session. Please be seated.
Good afternoon. Before we start, how do you all see it? The two cases obviously seem very similar, so what do you all suggest how we do this?
Thank you, Your Honor. That's exactly the reason I stood up to inform the court that the parties have discussed making, subject to the court's approval, making one argument. Both cases were heard together in the Chancery Court, and we would propose, unless the court feels there are some fact-specific questions, we are agreeable to arguing both cases at one time.
No, I think that's fine with us. As much as we would love to hear the same argument the second time, I think it's a better way to do this. And if we should run a little bit long because of any fact-specific questions, we'll obviously give you a little extra time as necessary on that. Okay?
Thank you.
Good.
Thank you.
Call the first case, please.
Sevier County, Tennessee et al. Versus Tennessee State Board of Equalization et al.
We'll hear from the appellant.
I would like to reserve 3 minutes for rebuttal.
That'll be fine.
Thank you. May it please the court, my name is Stephanie Coleman, and along with my co-counsel, Doug Overby and Robert Lee, I represent the appellants, Sevier County, and its property assessor, Mr. Thomas King. The Laurel Crest and Crown Park Vacation Resorts, which were designed, built, and managed by for-profit companies in order to generate ongoing income streams, are commercial businesses, not homes. Had the Chancellor below allowed himself to exercise his full authority under the proper standard of review, he would have overturned the Assessment Appeals Commission and subclassified the resorts as commercial. Back in 1975, the Tennessee Supreme Court explained in Snow versus Memphis why this distinction between commercial and residential really matters. See, just a few years before Snow, a commission created by the legislature had reported that property assessments varied wildly across the state, depending on the type of property, the usage, the location. So this resulted in the proposal of a constitutional amendment to set assessments at a fixed percentage across the state based on use. The Supreme Court stated that the purpose and objective of that constitutional amendment was to tax income-producing property at a higher rate than owner-occupied residences. The legacy of that amendment is found in Article 2, Section 28 of our Constitution, which states that commercial property is to be assessed at 40%, residential at 25%. So, how do we determine which subclassification to put a piece of property in? Our first clue was that 1975 Snow case, which distinguished between income-producing property and owner-occupied residences. But we obviously have to look at the constitutional language and the statutes as well. The Walter Kluwer's Legal Dictionary explains that commerce is the creation, sale, purchase, exchange, or transfer of a commodity or service for another thing or service or money. Tennessee Code Annotated 67-5-501 explains that commercial property includes all property used, directly or indirectly, or held for use for any commercial, private club, business, or similar purpose. So lots of things can make a piece of property commercial. It can be income producing. It can be held for use, even indirectly, for a commercial or business purpose. And commerce is the exchange of goods and services. In contrast, Walter Kluwer states that a residence is where a person lives and conducts the daily affairs of life. It's more than just where you sleep or shower. Otherwise, hospitals, sleep centers, European hostels would all be residences. The definition section that's relevant, again, 67-5-501, states that residential means property that's used or held for use for dwelling purposes. Walter Kluwer defines a dwelling as a building where a person lives or a building inhabited by at least one person on an ongoing basis. In short,
so, Ms. Coleman, the rub in this case is there is an ownership interest in this property. That's what would distinguish it from a hotel, for example. So what is your response to the fact that there is an element of ownership in these properties?
Absolutely. The way a property is taxed is based on its use, not its ownership structure. So in the Crown case, the court looked at a piece of property that was owned by a business, a private commercial business that leased that piece of property out to a public utility. Okay? And the court said, we know you want to be taxed as commercial and industrial because you're owned by a private business and in commerce and you're leasing that property out for profit. But if we allowed the ownership structure to defeat the use of the property, we wouldn't have a single public utility in the entire state because they would just lease the property in an effort to get around paying the appropriate amount of taxes. You can't take a commercial business, a nationwide commercial vacation resort chain, come in, build a commercial vacation resort, and sell off tiny fractional interests of that property to individuals while retaining basically all of the control of the property and limiting the use of those people in an effort to defeat the fact that it's a commercial business that should be taxed at a commercial and industrial rate.
And am I correct in understanding through the record and the briefs that what the owners, they don't own a specific unit in the building? It's just an opportunity to stay either at that resort or another resort for a certain amount of time?
That is correct. So the ownership is not tied to a specific unit or to a specific time for the vast majority of the owners. Now, there are a few owners that for a limited period of time have the right to reserve a specific unit, but that window only opens up for about 2 months. Most of the owners, their ownership interest is not tied either to a specific unit or to a specific time, just a season. And it is represented by a points system that they can use essentially to purchase time either at this resort or at any other resort that's affiliated with the club system, which is affiliated with their particular resort.
Is there a percentage breakdown for these two separate taxpayers here, but is there a percentage breakdown for each one as to, excuse me, how many nights of occupancy are by owners and how many nights of occupancy are by those renting it?
Within the briefs and within the evidence that was presented, there are tables that break down which types of use are by percentage for the nights that are reserved at the different resorts. The taxpayer characterizes all of the use at the resorts by either timeshare interest holders affiliated with this resort or timeshare interest holders affiliated with other resorts as owner-occupied use. It's incorrect, however, to characterize the use of the resorts by people that have no ownership interest in the resorts as owner-occupied use. They have an ownership interest in a different resort or a different timeshare, and they are exchanging the right to occupy that unit for the right to occupy this unit. The exchange of goods and services, the exchange of a right, that is consideration for the opportunity to occupy the units. Even the use by people in the clubs that have an ownership interest in a different timeshare is rental use of this particular resort. With that framework, we kind of take a look quickly at the two resorts at hand. The Crown Park Resort has 109 condominium units. Laurel Crest has 283. They include amenities such as pools, hot tubs, saunas, fitness centers, parking garages, sales space, markets. Each resort requires a check-in and check-out and provides cleaning in between stays. At Crown Park, two entities are involved in the ownership and management of the resort. The first is Holiday Inn Club Vacations, Inc., which is the developer, and the second is its wholly owned subsidiary, Global Access Exchange, LLC, which operates a private club for the timeshare interest holders. At Laurel Crest, there are 3 for-profit companies involved. The first two, Blue Green Vacations Corporation and its wholly owned subsidiary, Blue Green Vacations Unlimited, are collectively the developer at the resort. The third subsidiary, Blue Green Resorts Management, manages the day-to-day operations. Collectively, these integrated companies operate these businesses to create ongoing income streams for their business. The first income stream is that the businesses provide all the day-to-day management and facility operations at the resorts for a fee. Second, they are marketing and selling the unsold inventory at the resorts and recognizing those profits. And third, they rent out the unsold and underutilized inventory to produce ongoing income. The resorts serve as income-producing property for commercial businesses and should be subclassified as commercial. But even if this court determines that the real property usage is residential, they must still be subclassified as commercial because they constitute 2 or more rental units. The statute and the Constitution provide that all real property that's used or held for use for dwelling purposes but contains 2 or more rental units is defined and shall be classified as industrial and commercial property. When you break down that language, it's got 3 requirements. It's got to be real property, it's got to have 2 units, and they got to be used for rentals. There's no question in this case that we're dealing with taxation of real property. So the question becomes, are there 2 or more units? Both resorts are comprised of multiple condos, which are further divided into 1-week units as timeshares. Taxpayers argue, based on Castlewood, that every timeshare interest which is held by an individual owner is no longer part of the integrated economic entity. But there's 2 problems with their interpretation of Castlewood. First, the taxpayers ignore the fact that both Laurel Crest and Crown Park contain numerous timeshare units which continue to be held and rented out by the developer, just like the units in Castlewood that were subclassified as commercial. Second, in Castlewood, the units that had been transferred to individual owners were no longer subject to being rented out by the developer. In contrast, at the resorts, even a specific timeshare interest held by an individual is still subject to being rented out by the developer for profit. Okay, and we've discussed the fact that they are rented, which means that they meet the 3 criteria for being classified as commercial property under the Constitution. If the chancellor in this case had allowed himself to apply the proper standard of review, he would have overturned the Assessment Appeals Commission. When appellate review focuses on construing a statute or the Constitution and applying that language to undisputed facts, the review is de novo. From the bench, the chancellor dictated several pages of factual findings based primarily on the testimony of taxpayers' witnesses. Virtually all of the information in these 2 cases about the way the resorts are run and operated and what happens at the resorts comes from the taxpayers and is undisputed. Following the chancellor's description of these facts, he says, "These things look straightforwardly, for all the world, like commercial vacation resort operations." His conservative approach to his authority on review stopped him from overturning the Assessment Appeals Commission. However, there's no doubt how he would have held if he had permitted himself to exercise his full authority under the statute. The Laurel Crest and Crown Park resorts are income-producing property for the businesses that created and run them. They are not owner-occupied residences. No one lives there. We respectfully request that this court find that Crown Park and Laurel Crest are commercial properties which would be assessed at 40% of their value for real property tax purposes.
Thank you. Every time for rebuttal. Hear from the appellees now.
Good afternoon, Your Honors. I'm Chris Wilson of the Nashville Bar here on behalf of both of the HOA entities that are the appellees in these matters. The sole issue in this case involves the question of whether or not condominiums that constitute part of condominium units in Sevier County, which are owned under Tennessee's timeshare regime, should be classified as residential or as commercial, as advanced by the appellants. In this case, we're focusing, though, on a definition, a particular statutory definition of what is residential property, and that definition is set forth in 675501, subpart 11. And this definition, as judicially interpreted by the courts in Spring Hill and Castlewood, requires that property used for dwelling purposes, which contains only 1 rental unit, must be classified as residential unless 1, it's under common ownership with other rental properties, allowing the potential for an aggregation, and 2, it has to constitute part of an integrated economic entity. In this case, the facts in the record contain no dispute that the condos at issue are separate legal parcels and that they're each used for dwelling purposes. The record in this case also unequivocally establishes that the condos at issue lack common ownership. I would like to correct one misnomer from the oral argument so far, is that in this case, owners of these units, they purchase under fractional interests under Tennessee's timeshare regime, but they do have deeded interests in these units. That is a there is a deeded interest held, and there is an ownership interest in real property for each of these properties. It's divided up, though, among various fractional owners. And each of these units has a different mix of ownership that could be between different individuals. It could be certain percentage interests still held by a developer to be sold. It could be, in some instances, interests that are held in trust. But there are deeded interests in these cases. And this fact alone...
Do you agree with Ms. Coleman's argument that these condos as a whole are income-producing properties as opposed to places where people actually live?
I disagree with that, and it's more complicated than a broad assertion in that regard. The timeshare ownership provides a method for people, probably, oftentimes middle America, to have purchase an ownership interest in a vacation property which is shared with other owners. And in that case, the owners can utilize those, and oftentimes do utilize those properties. The evidence in the case here, particularly with one of the properties established, mostly owner use. But that being said, it's a vacation property that is shared with other owners. And whether or not there is rental activity that occurs, rental activity in this case is really a misnomer, and it's a diversion because of the fact that you don't have a common owner. You don't have a group of 109 units or 283 units, depending on which resort you're looking at, where you have a common owner that's renting these out to generate income for these properties. Very, very different set of facts than what you faced in the Spring Hill or Castlewood decisions, where you did have a single common owner that wholly owned a bunch of either condo properties in the case of Castlewood or individual single-family homes in the case of Spring Hill, which utilized those properties to rent out to generate income for the owner. In this case, you have a big mix of owners, some of which admittedly do trade usage with other owners of other interests at other resorts, some of which utilize the property. In some cases, it's undisputed that the developer has some interests, fractional interests, that may be rented out, but you lack a common owner, and you lack, the second part here is there's a lack of an integrated economic entity. You have a broad, diverse mix of ownership here. This is not a situation like, for example, a hotel where you have a common owner that's renting out properties to generate income for a single owner. You've got multiple different divergent interests that are involved here. And it's the complicated nature with this is that you have single condominium units that have multiple different shared ownership. And I'll also like to address as well comments that were made with regard to check-in procedures or items or agreements between parties to facilitate shared usage. Yes, there are requirements where owners that they have, as far as reserving use and have various other procedures in place, which are a necessity when you have one condominium unit with 52 or more fractional interest owners. There has to be agreements between parties in place to facilitate shared usage, which admittedly is in place here for these properties. But to argue that the parties don't have the right to agree to methods of shared uses and to procedures to facilitate that shared use goes against the very fundamental ownership rights that are associated with ownership of property. You have the right to contract and to make agreements between owners as to how properties will be utilized and shared.
What about other courts from other jurisdictions who have considered this issue? Is there any consensus from other jurisdictions about how to treat timeshare?
I think that the best the discussion of this is in amicus briefing before the court here. I can't speak to every single state out there, but the general consensus from my understanding is that this is not treatment of a timeshare unit as a commercial enterprise is not it's not what states are doing with that. But then again, states also can have very different laws when you get into the realm of property taxation. So, but I'm not aware of any case out there that is dealing with providing that they are like a commercial enterprise, like what's being advanced here.
Is there any breakdown on the record as, for example, 109 units, taxpayer 109 units? Is there a breakdown as to each of those 109 units, how many nights a year they're occupied by an owner or by just a vacation renter?
There is data in the record regarding a breakdown of overall nights, but not on a per unit basis.
All right, what is it on the overall nights?
It's on a breakdown of overall, like on a night. If you looked at the properties as a whole, there's some data in the record that has a breakdown, but not on a unit by unit basis.
Looked at like a 3-year period from 2016, 2019. Is that right?
I didn't hear you, Your Honor.
I'm sorry, I had my hand up. That was my fault. My wife points that out to me oftentimes. So, I think that it looks, as if I recall, there's like a 3-year period where it said here's a percentage that were in the units as a whole. All 109 units were occupied by an owner.
There are overall percentage breakdowns that would be applicable across the board, but not on a unit by unit
I understand.
basis.
As to the whole 109, what's the percentage that when they're occupied by an owner, and then what's the percentage when they're occupied by someone renting it?
By someone renting the property?
Who's not an owner.
I don't have the percentages in my mind. I know that they're laid out in an exhibit in the record, Your Honor, and I apologize. I don't have the precise numbers in my mind, but I will point to a couple of things that go toward this. There's an argument that was raised about developer-owned inventory. In the record, there's the percentages that the developer-owned amount of inventory in these cases is small. There's also in the record that...
Is it 2 or more units?
I repeat.
Is it 2 or more units? It may be small, but what do you mean by small? Is it one?
It's a small percentage of ownership, of fractional ownership interest. There's not a case where where there's an entire unit that there's like a shared interest. They would be treated the same as any other owner.
I understand. Of
the property. In this case, though, there's, like I said, there's a broad, diverse mix of ownership between these properties. And without the common ownership, that lends itself to the fact that there's not an integrated economic entity here.
Let's go back to where I understand the argument you're making.
Yes.
But I'm trying to figure out, and maybe it's immaterial, but I'm trying to figure out if the number of nights that these units, 109 in that one case, are occupied, is the majority of them they're occupied by owners, or is the majority of the time they're occupied by someone renting it for a pure vacation rental? And does that matter?
It doesn't matter. And the reason it doesn't matter is that you don't have...
If they were leased, I'm sorry, I asked you and didn't let you answer. Go ahead.
The fact that the properties are rented does not matter in this case, and the reason being is that you don't have a situation where you don't have a common owner between units. Without a common owner, there's no aggregation of the units here to meet the more than one rental unit standard.
So
in the definition
you're saying we should
itself.
look at each unit to see whether or not each unit is commercial or residential?
It's a unit by unit determination. These are separate legal parcels and with subject to different mix of ownership. You don't have a common owner between them, and without a common owner, it does not provide you a basis to aggregate these properties to exceed the more than one rental unit.
Does Sevier County send out 109 separate tax bills?
Each of the units are separately assessed in this case, under the Timeshare Act, there's in their briefing some statements about the Timeshare Act, and there's a provision in there under 6632-103 that talks about that timeshare owners are deemed to have fee simple fractional ownership interests in these properties. It's a fee simple interest, and they're treated as separate interests except for purposes of real property tax, in which case the intent of that statute is that even though there's multiple fractional owners, you assess each condominium unit separately as its own condo single unit with multiple owners versus trying to assess and value and tax each timeshare ownership interest separately. So yes, there's a bill for each unit, and they're each separately assessed as independent units, which lack common owners, and therefore you never exceed the more than one rental unit requirement under the to take you outside of the residential property definition, regardless of how much a unit may or may not be rented. A couple of points.
So if
Oh, go ahead.
90% of the nights were occupied in the whole 109 units, if 90% of those nights were occupied by vacation renters, wouldn't make any difference.
It makes no difference. And in this case, the reasoning for that is under 675501. The statutory definition of residential property explicitly provides that property can be rented and still qualify as residential so long as you don't have more than one rental unit. And in this case, without a common owner, you don't have more than one rental unit, which is an interesting item. They bring up the Shields Mountain case in their briefing to try to distinguish this result. And it's interesting to note that, of course, in Shields Mountain, it did not deal with the statutory definition that we're dealing with here. But in Shields Mountain, you did have a single-family residence located in a neighborhood that was being subject to short-term rentals. And if you were to have applied the statutory definition in this case, that residential property is all real property held for dwelling purposes that contains not more than one rental unit, regardless of how that property might be classified for purposes of the restrictive covenant at issue. In that case, it would still qualify as residential property in Tennessee. And that goes back also to the Snow decision in this case. The Snow decision is cited in the briefing, affirms that result, that you can have a residential property, so long as it contains not more than one residential unit, it can be rented 100% of the time and still fall within the residential property definition. And that's what we have in this case, is that we have properties without more than one rental unit. You have no common ownership, no common economic enterprise between these properties. And that's a fact that the appellants cannot dispute in the record. In fact, there's not one citation in the record that they've brought to anybody's attention here to dispute that fact. A couple of other quick points I'd like to point on is that the appellants misconstrued the Chancery Court's analysis in this case to try to assert that the court misapplied the standard of review. But the court in this case, that's simply not the fact. A review of the court's ruling and a review of the underlying record and the transcript of the hearing here shows that the court applied the proper standard, the 4-5-322H under the Administrative Procedures Act, as found applicable to these matters by this court in Kress v. Board of Equalization. And in applying this standard, the Chancery Court applied Tennessee's statutory law and case precedent, as well as the construction canon that taxing statutes must be construed strictly against taxing authorities. So to the extent that there's any question about the applicability or the interpretation of the residential property definition, it's to be construed against the assessor and in the appellee's favor. They also looked into the record, and nothing in the record suggests or insinuates either that the Chancery Court did anything but review the legal questions before it on a de novo basis. Nor is there any reference in the record where the court defers to any agency interpretation of any tax statutes or classification statutes in this matter. Rather, the court applied the law and the proper construction standards in reviewing this matter, and they also looked into the record to see, do the factual determinations made by the AAC in this case, which one being that there is no common economic enterprise at issue here, which would allow these properties to be aggregated. The court reviewed the record, and there was nothing in there to show that it was not supported by substantial and material evidence in the record. In fact, all the evidence in the record shows there's a lack of common ownership here. There is a lack of a common economic enterprise. And for these reasons, we would, and for all the other reasons set forth in our briefing, we would ask the court to uphold the decision of the Chancery Court and to also disregard the additional arguments aimed at the Assessment Appeals Commission that the parties have raised for the first time on appeal, which should be deemed waived.
Thank you.
Thank you, Your Honors.
We'll hear from the appellant in rebuttal.
May it please the court, I'm Doug Overby, along with Stephanie Coleman and Bobby Lee representing Sevier County and the Sevier County Property Assessor. Members of the court, I know all of us have heard for a long time a phrase from Oliver Twist that says the law is an ass. And it may have made sense in the context of Oliver Twist when Mr. Brownlow said that because a wife is presumed to follow the instructions of her husband, that the husband is guilty along with the wife, to which Mr. Bumble replied, the law is an ass. We've all heard that. I don't agree with that. I think the law is always here to come to a just result, to a correct result. And there's been a lot of talk in the briefs, writing in the briefs about the standard of review and the scope of review, the statutes, the prior cases. And I think all of that is to lead us to what is a just result in this case. And I really think the Chancellor hit the nail on the head when he also used the old phrase, if it looks like a duck and walks like a duck and quacks like a duck, it's a duck. This was actually the finding of the administrative law judge who heard the facts in this case. I think the administrative law judge in this case also hit the nail on the head, and it responds to many of the arguments of the appellee's counsel. I'm quoting from the Laurel Crest opinion, initial decision, and order, where it says the administrative judge finds that the taxpayer's fixation on the language referencing the number of rental units used for dwelling purposes is an effort to unduly elevate form over substance. The administrative judge finds that the taxpayer and affiliated business entities, and he names all of the affiliated business entities, used the resort directly or indirectly for the commercial purpose of producing income by providing transient vacation accommodations to thousands of guests each year. The administrative judge finds that the operation of the resort was not meaningful, distinguishable from the operation of any vacation destination resort. I would like to answer, Judge Sweeney, your question. Also in that opinion of the ALJ in the Laurel Crest case, and I didn't have the Crown Park decision handy, but at page 7 in that case, you will find where the ALJ finds the percentage of available nights used by actual owners of timeshare interest in the subject resort is minimal, as shown by the following chart excerpted from the assessor's post-hearing brief. And he goes back to 2014, which was a high of 11.1%, and follows it down to 2018, which was a low of 6.2%. And then the ALJ said, thus it necessarily follows that the vast majority of subject resort usage is through a rental, club, exchange, or marketing, but not by actual deeded owners of subject resort timeshare interest. So it's there and it's in the record, and it was minimal, and it's not enough to distinguish. I know that I'm over my time, but I think under the standard of review, if the Assessment Appeals Commission, under its standard of review, which is the same as for the Chancellor and for this court, could overturn the administrative law judge's decision, then the Chancellor had the power also to overturn that decision and reinstate the administrative law judge's opinion, which I think this court has as well. Thank you, Your Honor. And I apologize for going over.
Court's thanks to counsel for both sides. We appreciate your oral argument today and your briefs. I think we understand both sides have made it very clear what your positions are in response to the issue, so thank you. Have a safe drive back to Nashville.